Today I'm going to be talking about this unwritten rule of the practice of law among lawyers all over the country. It is so commonplace, well known, that almost no lawyer makes this mistake. In fact, in a span of 9 years of my practice of law, I have seen lawyers make this mistake a total of maybe 5 or 6 times. But because I saw a lawyer make this exact same mistake yesterday in the Delhi High Court, it prompted me to think about it and actually make a video about it. What I am talking about is, what do you tell the judge when you are appearing as a junior associate before the judge seeking either a passover or an adjournment for your senior? What do you tell the judge? Now, it is a well-known reality in India that lawyers have to argue multiple matters before different courts on a daily basis. When I am not there, I send an associate of mine to take either a passover, which is a request to take up the matter after a few minutes or maybe a few hours, or an adjournment, which is to adjourn the matter to another date. Now, when I send my associate to take either an passover or an adjournment, as is the requirement of the situation, the associate is also given instructions as to what to tell the judge about where the senior is busy. Now, you either say, of course, that the senior is unwell if you just want to take an adjournment, but the senior is not arguing any other matter anywhere else. Because if the opposite party's lawyer or the opposite party itself finds your senior arguing a matter before another court, they will report it to the judge, who will then summon the lawyer, and the lawyer faces trouble. Therefore, if you are arguing the matter before other courts, and while I'm making this video, I understand that I am giving very dirty tips and tricks, but this is what this place has always been about, so we continue with it. If you know that your senior is going to be arguing matters before other courts, you go to the court and you seek passover or adjournment, as the case may be, citing that the senior is arguing the matter before another court. But if the court is not superior in hierarchy to the court before which you are making this request, it is always advised that by hook or by crook, you do not mention this fact. If just in case the judge asks, where is your senior? You must give, even if it is false, the reasoning to the judge that my senior is arguing a matter before the Honorable XYZ. This particular court should be superior in hierarchy to the court before which you are coming and seeking your passover or adjournment. The reason why is, and it is suspected on a lot of occasions by members of the bar, again because it happens very few times, but it is suspected by the members of the bar, and rightfully so, from whatever occasions we have seen this transpire in court, that if a junior lawyer tells the judge that my senior is actually arguing a matter before a court which is lower in hierarchy to your esteemed office, the judge on a lot of occasions, just like yesterday, takes offense at the fact that at a lower hierarchy, this matter is being argued and you are negating your duties towards this particular court. Now, it is very difficult to explain to the judge, who on some earlier occasion must have been a lawyer practicing law, that sometimes lawyers have to make hard choices about which matter to do and which matter to sacrifice in that particular moment. I might have a quashing petition listed before the Delhi High Court, but if I have a bail application which I have to argue before a sessions court, I will have to choose that bail application, because in this bail application, my client is in custody, spending time in jail, while in my quashing petition, presumably on most occasions, my client is already out, either on bail or without arrest, and I am now seeking quashing of the entire proceedings before the Delhi High Court. So I can still, at least personally, I would choose to go for the bail matter rather than the quashing petition. Now, there are other interplays at force as well. Say, for example, I know that the particular judge before the district courts in front of whom my bail application is listed, if I seek an adjournment today, the judge will list my matter for tomorrow itself. But if in my quashing petition listed before the High Court judge, if I seek an adjournment over there, and it is true that there will be a minimum gap of 1 to maybe 3 months for the next date of hearing for the quashing petition. So here now I have to decide whether I want to take a very, very short date for a person who is behind bars rather than a 3-month jump ahead for that quashing petition, or I sacrifice the quashing petition going for 3 months and focus on immediately securing liberty for my client, the accused person. So there are all of these variable factors at play. Yesterday also, something like this happened. I was waiting for my matter to come up before the Delhi High Court. The counsel for one of the parties mentions the matter online via the alternative link through Cisco WebEx mentioning platform. And the lawyer says, "My lord, I am appearing for the petitioner in the matter," to which the honorable judge says, "Why are you not here present physically in court?" And the lawyer says, "My lord, I was arguing this matter before the Saket court. I had to be here. I'm sorry for this." And at that moment, as most of the members of the bar expect, you get to see this very less in action. The honorable judge is visibly miffed with this and says that it is unacceptable that you deprioritize the Honorable High Court to such an extent that you're appearing before the District Court and you're giving it priority over the Delhi High Court. And we lawyers standing at the back, we could not help but sympathize with the advocate. And of course, it's never as simple as this. I don't know what matter was being argued at that point of time before the Delhi High Court in which the lawyer chose to appear through virtual link. But I understand the problems that we lawyers face. We have to see, all of these situations I've aforementioned, such as bail, the liberty of the person, some maybe property at stake. If something is not done today, my client loses the property, my client loses his liberty. There are 100 other factors at play. Judges, of course, don't understand this. Now, if you do lie to the court, what are going to be the implications? Practically speaking, a lot of occasions, I would say, I personally have not done this myself, but I've seen this happen on a lot of occasions, that the junior lawyer will lie to the judge and say, if you're appearing before the High Court, that my senior is busy arguing a matter before the Supreme Court, and the senior might actually be arguing a matter before the district courts. Now, here, in any case, statistically speaking, from whatever we've seen in the courts, there is maybe a 1 in 1,000 chance that the judge might say, all right, give me the details of the case in which your senior is busy before the Honorable Supreme Court. Usually it almost never happens, but happens in maybe say 1 in 1,000 chance when the judge suspects that you are lying to the court. Now, in this situation as well, the senior lawyer knows and therefore instructs his junior lawyer that I will be able to take care of it. And that is why I say that I am arguing this matter before the Supreme Court. If that 1 in 1,000 chance arises, the senior lawyer, I don't mean senior designated lawyer, but I mean the lawyer who is sending his junior. This lawyer, if asked by the court, all right, give us the details of the matter in which you're arguing before the Honorable Supreme Court. He knows that if you appear before the Supreme Court, if you're not an advocate on record, your name will anyways not show up at the top of the appearance slips, and you can always ask one of your other friends practicing law before the Honorable Supreme Court of India, and you know that this person has many matters on a regular basis. Maybe he is a representative of a state, or maybe he represents some private company which has huge number of litigations. These people will have numerous matters every single day, so you give that friend a call and you ask them to add your name to any one of the order sheets where appearances are being entered before the Honorable Supreme Court. Matter taken care of. And that is the reason why, because of this little hack, seniors have no problem telling their juniors to go and tell the Delhi High Court judge that the senior is arguing a matter before the Honorable Supreme Court. Even if they're caught, they'll be able to handle it. Ethically, all of it sounds very wrong. I don't encourage anything like this to happen, but this is a ground reality of what transpires before the courts of law in this country. Of course, one question that will come from you is, what if the junior is going to the Supreme Court judge and asking for a passover or an adjournment when the senior is arguing a matter before the Delhi High Court? In the Supreme Court, you say, my senior is arguing this matter before another bench of the Honorable Supreme Court, and if pulled up by the Supreme Court judge about which particular court your senior is arguing the matter, you say, I will find out and I will revert. My senior asked me last moment to take a passover and come to the court. And then again the senior goes and follows the same routine of asking that friend who practices at the Supreme Court to sneak in his appearance before that particular other coordinate bench of the Supreme Court as well. I hope I've not complicated the situation quite a bit. I hope whatever I've talked about makes a little sense. I do not personally, again, I say, do not personally advocate this myself, but this is a stark reality of the way the system works in this country, which lawyers might not agree to condone, but they should definitely know about this. If you like this video, please do the thumbs up, please subscribe. This makes the algorithm gods happy. Thank you.